1-822-011-819-NO Andrea Dent versus Marinos Bernitas.
He says reduce the costs and fees. You know what he should do? Why don't we produce his retainer, his hours, his hourly rate, his fees, and his costs? Let's see if mine are reasonable when we compare the two. He had 2 lawyers at trial. I had Ms. Chidiak there one day, and that's because she was primarily helping me with the exhibits that were being shown to the jury during my closing argument. He had 2 lawyers present every single day of the trial. To suggest that we should reduce our time is nonsense. He points to not one entry that is quote unquote exaggerated. As it relates to the transcripts, Judge, the rule is very clear. If you use the transcript, it's submitted to the court. It doesn't matter when you paid for it. That only makes sense because we take the Benny essay depositions sometimes months and months before trial. But then those transcripts are either read to the jury or played to the jury. We have to have arguments with the court on objections. He said to you, as what I believe to be a veiled threat, that'll be for appeal. He's not filed a timely appeal. His appellate period has expired. He may appeal this decision, but he's not going to appeal the verdict. He's nodding his head yes, so the record's clear. Before he even gets a ruling from you, Your Honor, he's telling you that he's going to appeal this ruling, which is just nonsense. He said, oh, I never thought opposing counsel was smart. I said very clearly in my remarks, he's a formidable foe. He told us he's tried 60 some odd cases. So I put every bit of weight into that. Listen, I'm not saying I'm the smartest lawyer in the world. I just outwork the other side. And that's what's reflected in my bills. I outwork the other side because Mr. Sakala is much smarter than I am. He's a better trial lawyer than I am. I just beat him this time. He said, that my client is uncollectible and throwing good money after bad. This plaintiff attorney told me in no uncertain terms he's going to go to trial because everybody always backs down to him. His irrational acts and the irrational position taken by the plaintiff, whether it's the counsel or the client, made it clear that I had no choice but to prepare for trial. He said the firm had no prior relationship and refused no other cases. Well, listen, I could have taken on work.
Judge, I did not
stop. To be quiet. Just be quiet, Mr. Sakala.
I could have taken on work that was higher than $400 an hour. I didn't because that's pretty close to capacity. And I knew this trial was going to last a number of days, and it did. I said, well, Ms. Combs could have just tried the case. She's an appellate lawyer. She's never tried a case in her life, probably never will. He doesn't get to choose who tries the case. Your Honor, I think that's sufficient. I would sure like to see Mr. Sakala's bills, his hourly rate, and his retainer. Maybe he just decided to do it all for free. I don't know, but I'll just accept the court's ruling unless you have any questions, Your Honor.
No, I don't.
Can I respond? Judge, a brief
No,
response?
you cannot. It was his motion. No.
Judge.
This case is premised at this point in time when we look at the costs on the wood factors. The court, I believe, previously dealt with them as the court got to the point where it determined that costs and fees would be attributed, but it would needed this evidentiary hearing as to determine the exact amount. But I'll reiterate this: the skill and time and labor involved. We know that maybe this was a one-count complaint, but we know that there was a lot involved. There were experts, there were multiple depositions, there was back and forth, there were multiple motions in limine that were argued, and generally speaking, a motion in limine will help to streamline the case. So the Lord knows how this case would have developed if the court had not had the motions in limine to try to streamline some of these issues. And as it's been indicated, the majority of the motions in limine that were filed by the defendant were granted and the plaintiffs were denied. So there was a lot of time and effort that went into this case, even though maybe it should not have. The court also notes that the depositions were extremely lengthy, and as a result of the length of these depositions, the court subsequently instituted a policy which some of my other colleagues adopt, that there's a limit on defending essay depositions. I limit mine to 2 hours, but some of my colleagues limit theirs to an hour. But the inordinate amount of time that was spent on these depositions was the impetus of the court setting a limit for these depositions. And that was something that we had to deal with that we shouldn't have had to deal with. Additionally, the likelihood of the success. We know that the case was evaluated for $80,000. There was an offer of judgment on the table, but nevertheless, at the trial, the plaintiff asserted a demand of $600,000, and that also led to the necessity of having to go forward due to the claimed amount that the plaintiff had asserted. We know that Mr. Weaver could have accepted other cases during this time frame. However, as a result of the time that he had to attribute to this case, he couldn't take on any additional files and it did take away from his time working on other files. The fees customarily charged, the court did hear and did review the state bar economies of law, and the court notes that Mr. Weaver did assert a reasonable amount. There are a number of areas where Mr. Weaver could have charged significantly more, but based on a lot of the factors that are involved in this case, and for this particular case, he only charged $400 an hour, and the associates charged $290, which were reasonable and below the average rate that are recommended by the State Bar of Michigan. So those rates are appropriate. The amount in question as a result and the result achieved, as the court previously indicated, the case evaluation was $80,000. The plaintiff requested $600,000. The defendant made offer of judgment of first $500, then $1,000, but the jury came back with a no cause of action in this case. So it was more in line and favorable to the defendant. The expenses incurred were reflected in Exhibit 7, and Mr. Weaver articulated those expenses that were incurred from the time frame which are permissible under 2.405. We know in terms of the time limitations imposed by the circumstances, this case shouldn't have taken 7 days, but it did take 7 days. So we had to deal with it. There were multiple subpoenas that were proffered, and even though all of them weren't called, the defendant had to prepare for them. The relationship with the client, even though Mr. Weaver indicated that he didn't have a prior relationship with the client, he's indicated that this was a situation where the defendant had 2 prior attorneys on this case, and Mr. Weaver was the third, and Mr. Weaver assumed the responsibility of being able to go forward with this case to its end, and he did so. Professional standing experience of the attorney, we've been through that. We know the bio of Mr. Weaver, and he's a capable, competent attorney. Has been practicing over 35 years with Plunk & Cooney, and is a equity partner and has been since 1997. He's practiced in a number of other states and has been pro hoc into a number of other states. And this was a case where Mr. Weaver took on this matter as an hourly rate versus a contingency rate. And he did, as I previously indicated, his rate was $400 and associates were $290. Based on all the foregoing, one, there's been a representation that the time spent on this case was not reasonable. And Mr. Weaver had indicated that some of the time he spent was not even recorded or reflected in his actual cost that he had presented to the court. So if he had dealt with all of the time that he spent, it probably would be greater than that which he articulated to the court. So the court is satisfied with the hours. The court knows that there was a significant number, 10 motions in limine that were filed. And it would have been more if Mr. Weaver had prepared them himself at his rate of $400 an hour. And of course, even after they were prepared by the associate, he did have to prepare for the matters to be heard before the court. So his preparation was reasonable, as well as the preparation of the associate who prepared the motion. And as the court indicated previously, that this helped streamline the case, which took longer than it should have, and it would have been excruciatingly long if we would not have ruled on those motions in limine. So the court finds that it was appropriate for the associate to prepare the motions for filing, and Mr. Weaver to prepare the motions to be argued in front of the court. That being said, as well as the costs that were involved, as Mr. Weaver indicated, it's acceptable to use those transcripts and those IMEs that were before the trial started, because they did use them in the course of the trial. So all of those costs are permitted. Therefore, court finds that the attorney fees that Mr. Weaver asserted in this action are appropriate. I think initially there were $61,951, but based on the additional cost for today, I think the total fees that were requested are $62,482.91. The cost in the amount of, I think my math is wrong, let me know, $12,835, and the expenses in the amount of $25,893.07. I didn't do the math to total that up, but hopefully, Mr. Weaver, you wrote down those numbers, and that total will be the total that is permitted. Mr. Weaver prepared an order presented to the court for entry, and the court will sign the same.
Your Honor, I don't have the cost. I don't know if that number is correct. It was the expenses were in the expenses section. The total expenses was $25,893. So I don't know where the court's getting the $12,835. There was no application for cost in this case.
Exhibit 10 and Exhibit 7 are the two documents. One is 12,008 something, the other 25,8 something. The total, Your Honor, 38,725. But I'll include that along with the 62,482.
Right.
0.91.
So what that is, the 12 and I can't remember the other number. Those two numbers total the 38.
Yeah.
Correct?
That's right, Your Honor.
And then the 62,000, I chose 428.91.
428, 480. Okay.
I think that's what I saw. I don't know if that's what I got off of page 9 of the brief, because I know initially I saw 61.
Yep.
61,951, I think, and then as a result of today, the 1,500 today, I think that's what brought it up to the 62,428.91. Am I correct?
I'll prepare the order then, Judge.
Your Honor, for the record, there was no exhibits offered into evidence at all, and any request for cost would be outside of the court's previous motion. There was no application for cost in this case. Those costs would all be prior to October 20th.
Whatever fees that are articulated in Mr. Weaver's brief, the litigation expenses, correct me if I misspoke, the litigation expenses.
Prior to October 23rd of 24. So filing fees, service.
I articulated what I was in there. They're set forth in Mr. Weaver's brief. The total.
Judge, I think you're right on that. On the hours, so we're 61,951, and we have an additional probably 3.5 hours between Ms. Griffin and I times 400. So that'd be another, I don't know how much that is.
Sorry, that's up to 300. 400 times 3.5.
Yeah.
It's $1,400.
$1,400. So I'll add that to the 61,951, and that'll be the number for the fees. All right, Judge. Thank you.
Thank you. I'll look for that to be submitted to the court for entry.
Thank you, Aaron. Take care.
Thank you.
Bye-bye.
Bye.
Bye-bye.